There are many different ways to terminate a contract legally. In this video, we'll discuss the top 2 ways to do it. First things first, we must check the contents of the contract. Usually, a contract will stipulate many different ways in which that contract can be terminated. It is important to identify which one is applicable to you. A contract, for example, can be terminated by notice, by a breaching act by another party, or some other specified event occurring. For example, you are reaching the end of the contract. If you're in doubt, make sure to seek the professional advice of a contract review solicitor. Let's discuss termination by notice. Termination by notice is when one of the parties gives notice to the other party that they want to terminate the contract. There are usually certain formalities that must be met when terminating by notice. Number 1, we have to identify how much notice must be given. Usually it's around 30 days. Second, we need to determine at what point or when can you actually make use of that option to terminate by notice. For example, do you have to wait for 12 months until the contract length has expired to then terminate by notice? And lastly, we'll need to determine how that notice is to be delivered. So, for example, is it by email, by letter, and to whom? You'll want to carefully review the contents of the contract and especially the termination section if you want to terminate by notice. This is to ensure that you do it in a valid way. Before we discuss the ability to terminate a contract due to a breach of the other party, let me introduce myself. I'm Malcolm Zoppi, a qualified solicitor and the managing director of GZ Legal. GZ Legal is a corporate and commercial law firm, and we specialize in drafting and reviewing commercial contracts and conducting corporate law work. The second main way to terminate a contract is due to a breach of the other party. So, if the other party commits a very important breach of the contract, then it might give you the right to terminate the contract accordingly. Sometimes the written agreement will specify that you need to give the breaching party the possibility or option to try to remedy their breach, so put right what they've done wrong, within a specified amount of time, for example 15 days. If that is present in your contract, then you'll want to send the breaching party a notice to rectify their issue and state that if they do not rectify it within the specified amount of time, for example 15 days, then you intend on terminating the contract. You can learn about material breaches and other kinds of breaches in the video linked below. Thank you for watching. Make sure to check out the rest of the channel, which covers a range of legal issues which are relevant for small businesses in the UK. If you're interested in a free legal advice call, contact us now by visiting our website, which is linked in the description below.